And of course, this is the pulse here on Joy News, and your comments are welcome. Let's get interactive on our social media handles. We're on Facebook, we're on YouTube, we're on myjoyland.com, and of course on X Spaces. Now let's start from the sables of the Attorney General and Minister for Justice, Dominic Ayine, because he's mounted a strong defense of the government's decision to drop criminal charges against former Finance Minister Dr. Kwabena Duffuor and 7 others linked to the collapse of former Unibank, if you like. Now, Dr. Ayine explained that the decision followed a settlement offer received in March 2025 after negotiations revealed that under the agreed terms, assets worth more than 824 million cedis have already been handed over to the state. Additionally, a structured civil litigation pathway has been established to help recover a further 1.2 billion Ghana cedis.
Prolonged negotiations, the accused persons, by a letter dated 7th May 2025, made a proposal to settle the revised outstanding obligation of 3.3 billion Ghana cedis through a structured approach. The accused persons offered to pay 2 billion Ghana cedis in full and final settlement of the outstanding obligations through the following arrangements: 800 million worth of assets to be transferred directly to Unibank, which is in receivership, which will now make that available to the Bank of Ghana. And then their active cooperation and participation to assist the receiver to recover an additional 1.2 billion from the direct beneficiaries paid out on their instructions. Out of the above arrangements, the accused persons have provided landed properties valued at 824 million Ghana cedis to Unibank, that is, in receivership. Further, in other words, indirectly to the Bank of Ghana or the Republic of Ghana. Further, the accused persons will be responsible for any shortfall in the proceeds realized from the sale of the landed properties. A total of 0.5 billion has to date been recovered out of the 1.2 billion being pursued from the direct beneficiaries. Recovery of the remaining balance of 0.7 billion out of the 1.2 billion Ghana cedis and the realization of the landed properties provided are expected to be completed over a timeline of 18 months. Although the preference would have been for me and my team for the accused person to settle the proposed amount in cash, immediate settlement in cash was not, from my sense of what transpired at the negotiations, a realistic possibility or a realistic option. Both the criminal and civil cases have persisted over 6 years with no immediate resolution in sight. The complex nature of the legal proceedings has significantly delayed any meaningful recovery. While the criminal prosecution was intended to serve as a punitive and deterrent measure, it is through the civil process that actual recovery of funds is effectively pursued. The accused person's proposal fell within the receiver's mandate to maximize recoveries for Unibank in order to settle the bank's creditors, mainly Government of Ghana and some institutions. There is also a genuine risk that prolonged litigation could ultimately lead to lower net recovery, especially when accounting for legal costs, procedural delays, the time value of money, and the potential dissipation or concealment of assets. By contrast, the current arrangement secures the timely resolution or recovery of over 800 million Ghana cedis in assets and establishes a structured pathway for recovering an additional 1.2 billion Ghana cedis with the active cooperation of the accused persons. On the other hand, should the matter have continued in court, it would likely have faced prolonged delays, including multiple procedural applications, adjournments, and appeals. Even if judgment were eventually obtained in either the civil or criminal proceedings, enforcement and execution could take years, further deferring any meaningful recovery.
Now, providing further justification for accepting a 60% recovery threshold, he emphasized that the charges in the Unibank case were highly contestable, with a strong likelihood that the accused could have secured an acquittal by raising reasonable doubts in court.
Analogy assumes that these charges, that is the goat thief analogy, assumes that these charges could be proven beyond reasonable doubt. On the contrary, the record shows that the charges were contestable and there was a high likelihood that the defense could have raised sufficient doubt to procure an acquittal. And if that happened, as seen from the Beige Capital case, I would not have been able to recover even 1 cedi. Now, ladies and gentlemen of the media and my fellow countrymen and women, I can now disclose that Beige Capital offered me or my office 10 million Ghana cedis. You can ask the lawyers for Beige Capital. Ask lawyer, Tadio Sori. They offered 10 million Ghana cedis in settlement, and I refused. Today, I can't get 50 pesos from Beige Capital. So the dynamics are complex. Those who are oversimplifying it and saying this is the good, thief scenario, must understand that, it is more complex than just saying that the Attorney General says bring 4 goats and then keep 2. Third, by the time I assumed office and was approached by the lawyers for the accused persons, no asset tracing had been undertaken and no freezing orders had been obtained by my predecessors who filed the criminal charges. I could have been faced with a situation where the thief would have eaten 4 of the goats, thus leaving me with only one possibility, to recover only 2 goats. All right? In other words, assets depreciate. Lastly, in respect of the case at hand, 100% recovery was not possible and a conviction was not guaranteed. In the circumstances, my team and I agreed to set a realistic threshold of 60% recovery. Sorry. We recovered 824 million worth of assets, which will be handed over to the state, and established a structured pathway for recovering the additional 1.2 billion Ghana cedis through the civil, process. And these are monies that are being held by third parties that owed Unibank, including, for instance, and I think that this is very important, contractors owed Unibank at the time that it was placed in administration 2.9 billion Ghana cedis. Unibank made overtures to the state to say, look, the Minister of Finance, pay the contractors and let the contractors, because they will be paid through our bank, we can take the 2.9 billion and we can satisfy, our books will, improve, and we can stay afloat as a bank. The then Minister of Finance flatly rejected that and put and with the help of the Bank of Ghana, put Unibank into the situation in which we find ourselves. All right? Our current finance minister could have put NIB through the same process, right? But instead of using money to collapse a bank, the Honorable Atuforsen has used the money to revive it, for it to keep jobs and then continue to operate in the banking sector.
Well, so that's the Attorney General on the reason why he discontinued the case involving Dr. Komunado for the founder of the defunct Unibank and 7 others. Now, he also spent some time to talk about other cases that are before the Attorney General's office, and he reviewed that, for example, the filing of charges in the National Service Secretariat scandal, initially set for last week, was postponed after investigators uncovered fresh evidence of wrongdoing. This, according to the Attorney General, involves the transfer of 189 million Ghana cedis to the Bank of Ghana account, out of which 80 million remained unaccounted for. Listen to why he is treading cautiously on the filing of case against persons under the NSS scandal.
Trials have commenced in the case of the Republic versus Kobina Edubohe and 3 others, and that of the Republic versus Solomon Asamoah and another. That is the SkyTrain case. In the Kobina Edubohe case, we are calling only 3 prosecution witnesses. Our first witness has concluded his testimony. But for the third accused person's sudden withdrawal in open court of a lawyer's service, our first witness would have been discharged to give way to the second prosecution witness to start testifying. We expect our second witness to start testifying before the beginning of the legal vacation on July 31st, 2025. In the SkyTrain trial, we have concluded the case management conference concluded the case management conference. It is important to add that, but for the change of solicitors and the multiple medical excuses of the second accused person, that is Prof. Ameyaw Ekumfi, and recently of the lawyer for the first accused person, we would have called 2 of the 6 witnesses by now. That notwithstanding, the trial in the SkyTrain case is expected to start before the beginning of the legal vacation. The National Service Authority scandal case was due to be filed last week, as promised, when we stumbled upon evidence of malfeasance involving an account at the Bank of Ghana to which had been transferred an amount of 189 million Ghana cedis. Out of this amount, 80 million Ghana cedis cannot be traced. But we found 2 checks bearing the name and account details of the former Director General, Mr. Ose Asibe, which had been used to withdraw funds totaling a little under 2 million Ghana cedis from the said account. We have therefore halted the filing of charges so as to await the receipt of the evidence from the relevant state agencies, including the Bank of Ghana, Ministry of Finance, and the Controller and Accountant General's Department. In fact, as I speak, the Bank of Ghana signaled to me that this morning they are going to deliver the entire, bank statement, for my attention. Sorry. I am, however, happy to announce that at least 8 suspects in this investigation have approached my office for plea negotiations, including 3 former officers of the National Service Authority. Some officials have offered to testify against their colleagues, and some vendors and service providers are willing to come clean and testify as prosecution witnesses. When you build your docket well, this is the result that you get.
Meanwhile, the Economic and Organized Crime Officer, Yoko, has completed investigations into the Ashanti Regional Chairman of the MPP, Bernard Nchubu, also known as Chairman Wuntumi, and the former CEO of the National Buffer Stock Company, Dr. Ayine, says findings from these investigations will soon be made public. He added that the police CID has also finalized dockets on the Quanta mine and also owned by the Ashanti Regional Chairman Wuntumi, and the case has been submitted to them for appropriate authorities for action. Charges have also been filed, and suspects are expected to be arraigned soon.
A report on the docket for the oral cases, including the mathematical sets, the All Africa Games, and the drip scandals, are being prepared by the National Investigation Bureau for my attention. I expect to receive that investigative report in a few weeks for work to begin on filing charges in court. The Economic and Organized Crime Office has completed investigations in respect of Wuntumi, Chairman Wuntumi, and the former National Buffer Stock Company CEO, Mr. Abdul Wahab Hanan, and their accomplices. The results of both investigations will be announced very soon. The police CID have also completed a docket on the Akonta mining case and submitted same to my office. We have prepared charges and sent them back to the police CID for the suspects to be formally charged before their arraignment in court in the coming days. Ladies and gentlemen of the media, my fellow countrymen and women, in conclusion, I wish to remind you of the fact that when I announced the Kobina Edubohin investigation, I was blunt in stating the fact that I am open to engaging in plea bargaining with those who have been investigated and found to have looted or stolen state resources. I minced no words about my intentions and will therefore not shut the door to any accused person willing to enter into negotiations with my office for purposes of reaching a plea agreement. My approach is in consonance with the central plank of the oral, which is to recover the loot, which is to recover all the loot. But of course, you use all advisedly, because as I have pointed out clearly, it is not in all cases that it is possible to recover all the loot. So you recover some, realistically possible.
All right, so that's the Attorney General and Minister for Justice, Dr. Dominic Ayine. Now, let me bring you highlights of what he spoke, and then I'll bring in my guests as we try to make sense of what we were told this morning by the Attorney General and Minister for Justice. So there on your screens, a summary, if you like, of what was said at the news conference this morning, running into afternoon, by the Attorney General and Minister for Justice, Dr. Dominic Ayine. good time to bring in some persons connected to this matter as we try to analyze the issues that the Attorney General presented to the nation this morning at the Jubilee House. Now, joining me, the former Deputy Attorney General, Alfred Tuanyewa, who is now into private practice, anti-graft campaigner Adam Sinan, and of course, Suleiman Abrahima, Executive Director of the Media Foundation for West Africa. Let me start with you, Mr. Abrahima, and of course, Council Tunya, and of course, Adam Sinan. Good afternoon, also welcome to the program. So, Mr. Abrahima, last week when the AG issued that press statement, you wrote on your Facebook page, and you needed clarity on the third and the fourth point. And you asked the question, does it mean that if Kofi Annan stole or misappropriated 100 million of state funds and are facing prosecution, you will or may discontinue prosecution if you are able to recover up to 60 million, or 60+% of the stolen or misappropriated funds from Kofi and Amma? Please explain, because this may make stealing or misappropriation of state funds very attractive venture. After all, if you are caught, all you need to do is to possibly avoid prosecution by the AG. You put this on your social media handle, Facebook. The Attorney General today responded to some of the comments he's heard on the social media. I want to find out first of all whether these questions you asked of the Deputy AG and the response or the presentation by the Attorney General today satisfies the questions that you asked.
Well, thank you very much. I think that as a Ghanaian, as a non-lawyer, as a citizen who would want to see this country prosper for myself and for future generations, I still find the presentation quite curious. But I should also say that, well, it is commendable to see the Attorney General seek to be transparent, seek to provide information on whatever works are being done. Now, I think in the spirit of transparency, it would have been also important for the Attorney General to indicate to the Ghanaian public that, in any case, he was a defense counsel for Dr. Kwabena Duffuor in this matter. I mean, I think that transparency would have required that full disclosure, and that wouldn't have in any way undermined whatever position that he's taking on this particular matter. But from what has been said so far, it still doesn't take away the fundamental point about the fact that, well, people can cause financial loss to the state, people can commit acts that leads to the state losing so much, and in the end, what they can do, or part of the things that they can do to still go free, is if they can afford to part with part of the monies that have been lost. We are told in this presentation that eventually the ultimate figure came down to 3.3 billion.
Right.
And that out of that, a settlement agreement of 2 billion is what has been agreed to. And out of that, some are being recovered through assets and others are being recovered through people being chased to make certain payments. What it means is that ultimately, as a state, we are saying that we are okay, or we've lost 1.3 billion. And as the AG wants us to believe, it is either he accepted this or accepted the possibility of not getting anything at all, or going on and on and on with prosecution without some significant results. I think that the situation is really still very, very problematic because I see this as if this is what we're going to be building on, then no rich man, no endowed person would ever suffer the consequences of, depriving the state of resources, because in the end, they will come under plea bargain, make available some of the money. I wouldn't have had a problem.
Right.
If we are talking about a situation where all the monies have been recovered, or all the assets and whatever was lost has been recovered, and therefore the state says, well, since we've recovered it, we are freeing the person. But here we are losing 1.3 billion. The people who led to this are going for free, and then we are saying we are okay with a part of it. I think that it is still very, very problematic, and this requires some national conversation to see whether this is how we want to fight corruption.
But the summary of it points to the fact that half a loaf of bread is better than none. He referenced the Beige Capital case where lawyers for Mr. Hinaku had approached him, offered 10 million Ghana, he rejected. The matter traveled its full length in court, and the state got nothing. And he says that in this case, he's done a great job by getting some of the money back to the state, and so perhaps we should applaud him.
Well, I am not a lawyer, but I want to believe that there are reasons why we have a high court, appeal court, Supreme Court, all those ranks or categories of courts. And that, for me, is to suggest that, well, you may lose a case at the high court, and if you feel that you didn't lose it legitimately or you still have a case, that's why the appeals court exists. And ultimately, that is why even the Supreme Court is there. I want to believe that we are talking about the Beige Capital case on the basis of a decision that has been made by the High Court,
right,
and not the Appeals Court and not the Supreme Court. And I want to believe that the AG is not telling us that he did not accept that 10 million just because he didn't want to accept it. I would want to believe that he did not accept that 10 million because he felt there was a strong case under which the state can recover more than 10 million, or under which the person being accused could suffer some consequences to serve as a deterrent and punishment. So if he's now telling us that, the High Court made a decision as a result of which I'm not getting even 1 cedi, and I had earlier refused 10 million, I think it is important for him to let us know why he refused or turned down the 10 million. And as I said, it could only be because he felt there's a strong case. And if there is, and there was and there still is, the options are clear. The appeals court is there, the Supreme Court is there. We've had cases where the appeals court overturned decisions of the High Court. We have cases where the Supreme Court has overturned decisions of the appeals court. So I don't know why the AG would even, make a presentation to suggest that, well, I didn't take the 10 million knowing that I didn't even have a strong case.
Mr. Brown, I know you are hard pressed for time, but give me just one, so let me go over, because there's a question I want to ask you about the National Service Scheme, and then a revelation that came up in the AG's presentation today, when he makes the point that an amount of 2.1 billion cedi, which was alleged to be fictitious loans and fictitious transactions booked by Unibank prior to its placement in official administration, he makes the point that they may have cooked the books to present that figure. When they went into it, they realized that they didn't loot the money, but they have presented wrong figures or wrong books to the auditors, if you like. And whether or not this may constitute criminality, that is worth probing. But let me bring in the former Deputy Attorney General, Mr. Chianyebo. Mr. Chianyebo, good afternoon. Welcome to the program. We don't seem to have Mr. Chianyebo on the line, but let me also bring him Adam Senanu. Mr. Senanu, good afternoon.
Good afternoon.
Yes, good to have you. First, let me pick your initial reaction to the explanation provided by the Attorney General this afternoon, and then perhaps we can follow up with some few observations that we've made ourselves and to find and to seek your take on it.
Well, I think it's always good when we have public officers being responsive to issues. And on this one, the accountability platform, I think, is a relevant one. For some of the issues, if you look at the Dufour issue, it is useful to get the additional details, but the precedent being set and its ramifications for future similar cases is not clear. And so I did not find that part of it was addressed. Whilst we welcome the additional information, in my mind, I was saying So if you have another case, are we going to apply a 60%? How would equity before the law be managed? And so it raises concerns, and I don't think that has been fully addressed in this presentation. There's also the aspect of suppliers who owed Unibank, and if the state had paid those suppliers, they would have paid Unibank. And I think the amount in question was about 2.9 billion.
Right.
And the question in my mind was, okay, so why aren't we attempting to look at the entire 2.9 billion if that's something that they could pay rather than 2 billion? So there are still questions that are hanging. It probably will require listening to him a second and third time to try and figure out what trajectory they are taking on these issues.
But he explains why 2.1 billion Ghana cedis is not part of what the state was pursuing, Dr. Dofo and the 7 others. He says the 2.1 billion Ghana cedis is an alleged fictitious amount booked to the account of the shareholder, which did not involve cash outflow. And of course, he makes the point that perhaps to cook the books, to present a semblance of a bank doing well, and not the case that they looted the money. And this is another conversation for, presenting fake or, if you like, incorrect figures to the regulator, in this case, the Bank of Ghana.
Well, I think that would just mean that if you're doing any negotiations or plea bargaining and you discovered more facts that suggest that something untoward was done, you probably want to dig deep and be sure you have all your facts before you proceed to a conclusion. One of the questions I still don't have to be on it, when he said he and him read a 60%, and I'm wondering why what were the factors that led the conclusion that the 60% coverage was the most realistic view on this particular plea bargain that they were in.
All right. Let me see if we can have the attention of Mr. Afetuan Yabua, the former Deputy AG. Mr. Chuan, good afternoon.
Good afternoon.
Yes, thank you so much for joining us for this conversation. So first, this arrangement that the AG presented to us today, was it part of what you had in mind when you took this matter to court?
Thank you very much, Ayrton. Yes, this matter, when we took it to court, we had 3 or 4 objectives. 1, to prosecute, and if successful, get them convicted, and then also get the money recovered after their conviction. And in addition thereto, for them to also be punished in accordance with law. And so in terms of recovery, we don't rule that one out, but we're so clear in our mind that we had a very strong case, and that if nothing at all, at minimum, even if we're going to settle the matter, we should get 100% recovery.
But the AG makes the point that during the period that you were on this case, you made no inroads in terms of getting conviction, in terms of the recovery. For all those years that the case stood in court, no progress, no significant progress was made in terms of getting to the finality of, and what he's done rather has saved the nation money that, in terms of legal journey, would have amounted to nothing.
Respectfully, I disagree with the learned AG. This case started in 2020. We called the receiver. In fact, he was our star witness. The receiver appointed by the Bank of Ghana. He went through the books, came out with the figures that we used in filing the charge sheet. He came to testify. He was cross-examined. We also called our second witness, PW2. And so if there's this saying that we didn't do anything apart from filing it, that cannot be true. Then if you also look at the charges that we leveled against the accused person, you realize apart from falsification, apart from those falsification of account as one of the offenses that we charged the accused person. The point has been made that no recovery was made, but the AG knows that before he took over, 300 million Ghana, the amount that we charged the Bank of Ghana, current Bank of Ghana with, has recovered. But this notwithstanding, we're pressing the charges because we had the view that if someone did something untoward regarding finances and we're able to recover even 100%, the next step must be taken to also, in a way, punish the person, either getting the person imprisoned or let the person pay interest or restitution in addition to the original amount. So that's the very reason why this case was in court. We did a lot. It went to the Court of Appeal. It came back. They raised various objections. And so when I heard the AG say that he has examined the file, realized that the charges are weak and the possibility of joint conviction was very minimal, I beg to differ.
But
this is a case where we took serious steps to file the charges, line up our witnesses to prosecute it. With this new trend, what is being said, or what we are trying to say is that the other case in court, for instance, now we have the UT case in court, the same market attacking of the same set of facts. We have other, I'm not enough, but I know we have about 6 or different cases. The agents are telling us that all those cases will not be successful in court. And this is now going to arm the accused person, no case, to say, we are not going to pay you even once, because after you said that the cases that we filed in court are not strong cases, and you will need to recover even once to be. So I think the approach is something that I have a problem with. The AG simply could have entered NP, which I will not doubt he has that power to do. And then perhaps there is this explanation. But with these explanations, we are also fortified to also come out. And it's not helping the cause, because the AG has cited an example that because 10 million was offered by big capital Inaku, and he rejected, and now the guy has been acquitted and discharged, the state has lost everything. I beg to differ on that score also. That's why we have the Supreme Court. If the High Court has made a ruling that the person has a case to answer, and the Court of Appeal has said the person has no case to answer, any prosecutor may want to go up because the trial court, which heard the evidence, has come to a conclusion that you think that you ought to move forward. But if they are saying that they are going to appeal to the Supreme Court, what happens? It means that, as he said, we are going to lose everything. But how much was involved in the Beige Capital case? For 1.2 billion Ghana cedis. And which prosecutor will accept 10 million in settlement of an amount of 1.2 billion Ghana cedis? So, everything.
Right.
This 60-40 that the AG said they've come up to is a dangerous precedent, even though I concede that if we recover some amount of money, it's good for the state. However, we need to be very careful, very cautiously. I know as a fact that there are over 400 cases involving the banking sector cleanup. With this precedent, and with what the AG has said today, I doubt if you can even get one CD in the other case. Because the AG has said that for the breach of trust does not hold in such cases, he seems to be saying the other offenses will also not hold. Check the other cases and realize that these are the offenses or the charges that we leveled against the other accused persons. That's what I'm saying. It's a dangerous place and we need to watch out.
The minority has been speaking today, but before I bring you their take, let me ask you this question because you are a lawyer, and I'm guessing that Dr. Dufour obviously came to this decision to enter into this arrangement with the state based on the advice of his counsel. It's possible, right?
Very, very possible. Very possible. Usually, if you're a lawyer, your client may want to discuss the case with you, and you want to give him advice. So I think that definitely his lawyers gave that advice. But I've told his lawyers he wanted to take this line of action. Is
it possible that knowing the evidence that the states may have had in this particular case, and then the advice provided by counsel to Dr. Dufour, the state stood a better chance of getting full conviction and recovery if you had gone to court?
It is very possible because lawyers also look at the options. Sometimes you look at the evidence, you listen to your clients, and you may want to advise your client to avoid imprisonment. Listen, if you look at the charge sheet, if you look at the facts in this particular case, we are talking about 5.7 billion Ghana cedis.
The AG says 2.1 billion was, if you like, for want of a better word, cooked and not money looted.
I'm coming there. Yes, I'm coming there. 5.7 billion. Now we are being told that about 2.1 billion or something that was cooked. But who gave us these figures? The receiver. So the question I ask myself is, on what basis has the receiver now said or has now changed his position that the 5.7 that he gave wasn't the right figure, but rather now 3.3 billion? We need to ask these questions because the receiver, he went through the book together with officers and came up with the 5.7 billion. So on what basis are they now saying that it's now 3.3 billion? We need to get some answers from the receiver. There's also this issue about they having cooked it. If you look at there are laws in Ghana. If someone falsifies an account, what do? You prosecute the person for falsification of account. In that case, on what basis is the AG then withdraw the charges against these accused persons? If nothing at all, you could have maintained the charge of falsification of account.
But Mr. Chamba, is it also true that whilst the previous government attempted to prosecute this matter, Dr. Adofo approached the then finance minister and made a point that contractors owe his bank over 2 billion Ghana cedis. So if the finance minister was to pay the contractors, the bank would have been solvent, and this matter wouldn't have come up at all.
That's the side of Dr. Adofo. I never got to know about it. And as it's been said, the current AG was part of Dr. Adofo's team, either in the criminal or the civil matter. And so this 2.9 that they are talking about, I'm not aware of it. Even if he approached the then finance minister and that discussion couldn't go through, that will not absolve him from being prosecuted. It's like even if you've gone to steal, I'm giving an example, steal an amount of 10,000 Ghana cedis, and you are prepared to refund the 10,000 Ghana cedis. Does it mean that because of that decision, the state should not prosecute you? The state reserves the right to prosecute you. If nothing at all, can ask you to pay rescue. That's why, at time, we activated 2 sets of laws. We took the Section 35 of the Court Act, where you be charged with financial laws, and then that's why the Atuisian matter, we took that one. They also took into consideration the Plea Bargaining Act. We never entered NP because an accused person has had to make some payment. No. If an accused person wanted to make some payment, we just tell you, pay the full amount, and then you pay restitution. And that is the essence of justice. But if you are going to make it 60-40, as my other colleagues on the program have said, it is sending some kind of signal out there that now the ratio is 60-40. And also those who are now facing prosecution, as I mentioned earlier on, over 400 of them, 400 of these microfinance companies and then savings and loans, some of them are going through the same procedure. So now what we are going to do is that they will all say that they are not going to pay because they are now fortified. They believe that the charges against them cannot hold in court because per the AG's logic, those charges couldn't have been proven. Or they will say, we are prepared to give you 60% and they will keep the 40%.
So therefore, the state case against these 400 entities and individuals, we may be coming from a disadvantaged position because of the arrangement we entered into with Dr. Adofo and the 7 others.
Exactly, my brother. Exactly the case.
Okay. I'll come back to you, but let me bring in Mr. Suleiman Abrahama. Mr. Abrahama, you heard the former AG. He was on this case during the MPP administration. He thinks that this precedent is bad. But then also the Attorney General also took time to deal with the National Service, Secretariat and some withdrawals that has necessitated further probe into activity. The reason why we are here to see formal filings at the court to get those who the state deemed to have misappropriated funds to answer for their crimes. What is your take on that?
Well, I mean, it's a case that, of course, is of interest to us because, as the Attorney General did say during his previous press conference, this is something that the Fourth Estate, which is a project of the Media Foundation for West Africa, revealed, and as a result of which we are where we are today. But talking about this at a time when we are having a conversation about this whole idea of plea bargain and settlement of cases, I'm wondering whether the last time the AG talked about 547 million Ghana cedis, are we at a point where if the persons involved are willing to, for example, provide 60% or 70% of the amounts involved, the charges against them will be discontinued, or even 90%, the charges will be discontinued, or as perhaps Mr. Tuebo is saying, if the AG thinks that for these people, the case against them is strong, then we'll be looking at retrieval of the money and conviction, because certainly 547 million Ghana cedis, one would say if you can recover all, certainly that is better for the country. But should it even be about recovering and leaving the people to go scot-free? Because otherwise, again, the analogy that somebody cited that the AG referenced, it will be as though if I steal your plantain and I'm going away and you accost me and I'm ready to give you back your plantain in full, then there is no basis taking me on. I agree that this is something that we need to really, really examine quite carefully. And also, the fight against corruption has perceptual, importance. If people begin to have a certain perception that the fight against corruption is essentially about persons in maybe opposition parties and so on and so forth, I doubt we could be very, very effective. And since the beginning of this government, we've seen the discontinuance of a number of cases, but all those cases, coincidentally or whatever it is, have been cases involving persons who are either known or aligned to the NDC. If it continues this way, it will get to a point where people will have a perception that the only people against whom real corruption is being fought are persons on the other side and not persons who are aligned or affiliated with this government. As a country that wants to reset, I think it is important we do things in ways that do not create wrong or right perceptions. Otherwise, we wouldn't go far as a country.
The national service matter, and I'm bringing Kusasi from Parliament in few minutes. Already the AG tells us that 3 individuals, they've entered into a plea bargaining with him. Some he's turning into prosecution witness. Does that suggest to you that whatever crime they may have committed, because they have decided to help the state in prosecuting its case, they may also, not be prosecuted, and that means that whatever illegal benefit they're taking from the state, they get to enjoy it?
Well, I think it will be better to wait for the details of all these, because it could be that I am privy to the situation. I may not have benefited, but in terms of prosecution, I am getting involved. And so I can perhaps convince you that I did not benefit in any way, but I'm prepared to support your case so that you can have a strong case against those who really benefited in order to be set free. It could be so. But for me, if the issue of plea bargain, I've stolen 1 million, or as a result of my actions, the state has lost 100,000. If I can repay back the 100,000 with interest, or even in this case, we are not talking about with interest. We are talking about the actual monies. And the AG himself talks about, the time value of money and all of that. I am quite worried that as a country that wants to prosper, this may not be the route to take. Otherwise, it may incentivize people to do the wrong things. After all, if they are caught, what they can do is to either refund all and go scot-free, or better still, refund the percentage, keep the rest of the money or assets, and then go with their freedom.
All right, Mr. Suleiman Abraham, thank you so much for your time this afternoon. Before I bring in Adam Sedanun, of course, the former deputy AG, Mr. Afetuan Yeboah, the minority MPP in Parliament, they've served notice. They will proceed to court to challenge the decision of the Attorney General, Dr. Dominic Ayine, dropping criminal charges against the Unibank founder, Dr. Kobnado, for last week. The AG, as you have heard already, reviewed that the state had recovered 60%, and it justified why the state went into this particular conversation with Dr. Kobnado for. The minority, they've been at this particular matter in Parliament right after the presentation of the AG at the Government Accountability Series. But addressing journalists in Parliament, the minority will have none of it, and they've threatened to go to court to have this matter set aside. Let me bring in Parliamentary Affairs correspondent Kwaku Asante. Kwaku, so walk us through what transpired on the floor today.
There are a couple of things that the minority are asking for, and in fact, that news conference addressed by the spokesperson of Constitutional Legal Affairs just a while ago. Kwame Anyimegu said their side is prepared to go to court if this matter is not reversed, because they believe that there are a couple of issues that have come up that the Attorney General has not answered the questions satisfactorily, and that is why they will be going to court if Dr. Dominic Ayine does not actually reverse the decision to drop the charges against Dr. Kwame. Again, they raise the matter of conflict of interest. That's an allegation that they are now making against Dr. Kwame. I've heard in the interview with Alfred Trayeboa, and the minority actually said the same thing, that because Dr. Dominic Ayine at some point represented Kwame in some of the civil and criminal matters, those are matters that for a decision that is taken, perhaps it should have the case itself, it raises real matters of conflict of interest, because they believe that having acted as lawyer for Dr. Kwame, his judgment may have been impaired in dropping the charges against Kwame on this matter. Again, they raise the matter of the 60-40 deal that the AG is now talking about. They say, when exactly did the AG take that decision that when you are able to recover 60% in some of these matters, it would not make any sense to proceed to court and continue that trial? And so they raise questions about that. They also talk about transparency that has surrounded this deal. They believe that a lot of the issues that have been raised, the government has not been very transparent in answering the questions of the public. They believe that the AG addressed the public today, set its own questions and answered them. He has not done what exactly is appropriate in these matters. So 4 issues coming up. One, they say they are going to go to court if the AG does not reverse the decision. Conflict of interest. When exactly did this 60% recovery deal come up? Did it come to Parliament? Has it the blessings of the law and all that? And also matters of transparency. That is the news conference addressed by the minority a while ago by their spokesperson of legal matters. That is Kwame Anyimegu.
A select committee on constitutional, legal and legal affairs to summon the Attorney General to answer these questions publicly. The Legal Counsel and Bar Association to investigate potential breaches of legal ethics and professional conduct. All patriotic Ghanaians to stand up against what appears to be the erosion of justice and the dangerous politicization of the prosecutorial process. Finally, may this press conference also serve as a formal notice to the Attorney General, Dr. Dominic Ayine, that if his decision is not reversed within a reasonable time, the minority will consider its options of proceeding to court to challenge its decision in its entirety. Let it be known that justice must not only be done, but it must be manifestly seen to be done. Thank you.
All right, so Kwaku is with me. So Kwaku, they are also raising issues of conflict of interest for his previous role as lawyer for Dr. Dofour. But we know that he's no longer lawyer for Dr. Dofour, and he represents the state. And it's on the strength of the state that he's able to secure this arrangement that has got the state some money. From their view, where does the conflict of interest lie?
Minority will not have it. According to the minority, having served previously as the lawyer for Kwame Dofour, and in fact having made representation on his behalf in court, and actually advanced certain arguments to the effect that the case that the previous government, led by Attorney General Alfred Trayeboa, had built against Dr. Kwame Dofour was not solid enough, and that it was just politically tainted. And for him to now assume the chair of Attorney General and then decide that the charges will be dropped and 60% recovery is enough, they say there are matters of conflict of interest that the AG will have to respond to. Listen to Kwame Anyimegu on that matter.
Has Dr. Dominic Akuritenga Ayine in the past acted for Dr. Kwabena Duffuor and Unibank. In the case of the Republic versus Kwabena Duffuor and 7 others, is Dr. Ayine, now the Attorney General of the Republic of Ghana. The deputy referred to him as the Attorney General, and today he has granted a press conference acknowledging that he gave out the press release and he tries to justify why he entered the nolle prosequi. Ghanaians would want the Attorney General to explain to us in full the extent of conflict of interest using Dominic Ayine as defense counsel and Dominic Ayine as the Attorney General. This he failed in the press conference to tell Ghanaians that he had acted for Unibank and that he had acted for Dr. Kwabena Duffuor. So I think he owes us as a country a duty to explain to us why and the extent of this conflict of interest.
Well, finally, the matter of the 60-40 policy, the government says it has succeeded in bringing in some money from the defunct Unibank matter.
Yes, according to the minority, they are asking questions about when exactly this 60-40 deal was agreed on. At what point did the Attorney General or the state decide that it was sufficient for matters like this to go after 60% claim and then make it and then decide that the 40% should be forgone? These are matters that they believe that the Attorney General must answer. And for instance, they ask questions about whether or not this matter even came to Parliament. The Parliament approved of any transaction that if there are proceeds of crimes or alleged crimes of this nature, you are allowed to recover 60% and then decide that the 40% should be forgone. These are matters that they ask questions of. And so according to Kwame Nibadu again, he speaks for the minority on these legal matters. The Attorney General will have to answer questions on when exactly this 60-40 deal was instituted and what is the legal backing behind that.
This release makes reference to 60% recovery threshold as a benchmark for reconsidering prosecutions. When was this policy introduced and under what legal authority? Was this benchmark made public or debated in Parliament? Was it quietly introduced post-2024 to lower the standards of accountability? For a case involving 5.7 billion, can the Attorney General confirm that 1 billion has indeed been recovered and provide documented proof of the recovery? It is strange that the Attorney General is insisting that the amount of 800 million cedis recovered from Dr. Duffuor constitute 60%. How did the Attorney General review the amount from the 5.7 billion to 1.2 billion by a mere administrative fiat?
Before you go, they also have issues with transparency.
Yes, according to Kwame Nibadu, it would appear that the AG has not been answering the real questions. That is, the decision is shrouded in secrecy. The Attorney General has not been really responding to some of the matters. They believe that he has been setting his own questions and answering them. They are real matters having to do with transparency on this call that they believe that the Attorney General must answer. A lot of the demands they make and a lot of the claims they make, they frame them as questions and they put that to Godfrey, the Attorney General now, Dr. Dominic Ayine, to answer so that they can firm up the decision they've made, that ultimately this is a matter that they are going to take to court and challenge the decision of the AG to drop the charges against Kwabena Duffuor.
Transparency, as indicated in the press release, demands the learned Attorney General to explain to Ghanaians the principle of 60-40. Ladies and gentlemen of the press, once a nolle prosequi is entered by the Attorney General or the prosecution, we need not find out, and we don't need to find out questions. But he chooses to, if you read the press release, he chooses to justify why he had done that in the name of transparency. And that's why I say that transparency, as he had indicated in the press release, demands that he, the learned Attorney General, would explain to Ghanaians the principle of 60-40. If you're talking about 5.7 billion cedis and you tell us that you have retrieved 800,000 cedis, how can you say that that represents 60,000? And at any rate, is it a new policy directive, or when did this come into Ghana? When was this introduced into our criminal jurisprudence? What happens to the remaining 40%? To him, the Attorney General, today we heard him say that the 60-40, we can forget about the 40%.
Okay, so that's the minority's official reaction to the Attorney General Minister for Justice news conference today, explaining why they said entered into this arrangement with Dr. Commander 4 and the 7 others for the payment of 60% of the value of the money the state was pursuing them for in the Unibank matter. Mr. Edem Senanu is still here with me, and of course, Alfred Chuanyaba, former Deputy Attorney General, is so still on the line. Let me pick first, Mr. Senanu, is there a potential conflict of interest here? The AG was lawyer for Dr. Commander 4 when the NPP took this matter, the NPP administration took this matter to court. He's no longer the lawyer for him. It's not the Attorney General representing the state. But the minority says that there is potential conflict of interest. Do you see it that way from the standpoint of transparency and anti-corruption matters?
Well, yes. I mean, to the extent that he was a lawyer for Dufour, he may have changed. He's not engaging him as a client. However, typically you would find that the same rules that we apply for statistical issues would apply. The Constitution is clear that we do not even position yourself where there is potential conflict of interest. In which case, we would all have known that the optics of this would not have been the best. Typically, what you do to insulate yourself is to then recuse yourself and say, listen, just so that I'm not at the center of the narrative, some other senior lawyer or somebody else, this particular instance, would be the one who will be the figurehead. So I think that there is merit in anyone saying that there is a potential conflict of interest based on the historical record.
And then the issue of recoveries. I mean, there are over 400 cases, as we've been told by the former Deputy AG, there are over 400 cases relating to the banking sector cleanup. Now that the former matter appears to have been done and dusted, what is your expectation of the other cases that are pending before court with similar amount of money hanging on the necks of those who have been accused?
That was one of my initial immediate concerns, that how many other similar cases do we have? And why are we starting with this one? When the others that potentially one could focus on to get 100%, and how come this one has to deal with somebody who has some affiliation with the ruling party? In my view, if they had several other similar cases, why are we not hearing another case, something that would not raise any sort of conflict of interest, something that perhaps, because this sets a precedent. So I have similar concerns as the former Deputy Attorney General has raised.
All right, we'll leave it here for now. I don't know whether you're also happy with the transparent manner in which the AG updates the nation on investigation, especially on matters relating to ORA, and then what they are doing going forward.
Well, I am. In fact, if we had a way, we should be doing reforms of all the laws that the various anti-graft agents are empowered and given a money to make the much correct keep an eye to the country. It is why in 9-5 for the work, every is required to report. And indeed, we're expecting that to do it more. It will serve as deterrent those things that body high corruption.
All right, let's leave it here, Mr. Adamson. Thank you so much for your time. Let me end it with Mr. Chuanyabua. So the minority says they want to go to court, but you and I know that to file a null procedure is a prerogative of the AG. Why would they want to challenge that decision?
All right. I don't know whether they may want to challenge that decision, but what I heard them say is that they will be going to court. Maybe they are going to challenge the reasons behind the entry of null procedure. Because ordinary, if you enter NP, null procedure, you are not supposed to give reasons. But now that the AG has decided to give reasons, people may also want to go to court to challenge the reasons. It should be an interesting matter. Let's see how it goes. Then maybe to conclude on this point also, we may also have to look at how the amount 5.7 came to 3.3 billion. If indeed the AG saw falsification of accounts regarding that amount, I expect the AG to prosecute those who cooked that figure of 3.2.1 billion. They must be brought before court on charges of falsification of accounts. Then also the receiver who did the entire work and came to that amount, if he was involved in this current amount of 3.3 billion, then he also has some questions to answer. Does it mean that he also misled the state, a public officer like myself? He also should have some questions to answer, unless, of course, he is not aware of how come the amount got reduced from 5.7 to 3.3 billion.
And then this final matter, before I let you go, on the issue of conflict of interest. Now, you served as Deputy AG. You prosecuted some cases on behalf of the state. Now you are in private practice. In case some of the cases you were prosecuted whilst in government come up and then the clients come to you for you to represent him in court, will you do so? And would that amount to conflict of interest?
Currently, all cases that I handled as a prosecutor in the AG's office, if those clients come to me now for me to defend them, I cannot defend them ethically because I know the other side of the matter. So by ethics, I cannot now go and defend that I personally handled as a prosecutor in the AG's office.
And so the charge of conflict of interest you think is grounded?
Now, if you want to reverse it, that the AG was also current AG was in private practice, he must have represented some clients that is now in office as an AG. I mean, nothing stops him as the AG from going ahead to do his constitutional statutory duty as an AG. But I have this one example. Before I got appointed as a deputy AG, I had handled a matter, a criminal matter, and the matter was pending at the Supreme Court on appeal. Interestingly, when I got to the AG's office, I was put in charge of criminal prosecution. And that matter was a matter that I had filed and appealed at the Supreme Court, and it was coming on. Knowing that I did the matter in my capacity as private practitioner then, I decided not to even go close to that matter. It was the DPP's office and her attorneys who handled the matter. And already my client, especially I say my client, the client I represented in private practice, lost the case at the Supreme Court. So in some of these things, if an AG handled the matter in private practice and he comes to the office of an AG, I would expect that if such a matter comes up, maybe he must defer the matter to the DPP's office because I've been in that office. They are so professional, they are so diligent, and they can actually advise on a docket that you have assigned to them to do.
All right, let's leave it here for now. Alfred Chuanyabua is a Deputy Attorney General. He served in the Akufo-Addo administration. Let me bring in former Ambassador to the Netherlands, statesman, Dr. Tony Edu. Dr. Edu, it's indeed a pleasure to be speaking to you this afternoon. Good afternoon.
Good afternoon, sir. How are you?
I'm doing great, and it's good to hear your voice. And you are not happy with the comments by the Deputy AG and, of course, the panel. You think that the AG has done a good job?
There are some presumptions which must be corrected. First of all, this plea bargain thing, 60-40, is being criticized on presumption that Dr. Nadu is killed. But this is the critical matter. In itself, you have to prove both facts. and the message. And therefore, if the accused person can raise a single small reasonable doubt, your case falls. So, much as I will agree with the former Deputy AG that the functional part for the current aid to do in his presentation, the details of the case, would have been clear that he was Dr. Nadu's lawyer during the period when he was not the AG. But this is strange. Akufo Nana was the lawyer for Kofi. When Akufo became AG, he filed a non-prosecutor on that. So it's not a strange issue, but I would agree with that. It's the questionable thing currently to what was clear during his briefing of the press that I was the lawyer, and therefore I will recuse myself or whatever.
But
I hope you understand.
Yes, I do, sir.
Yes.
Yes.
Sometimes we shouldn't be jumping to the conclusion like the minority has done, that the whole thing has been politicized. The very commentary by the minority is also indicative of political considerations.
But should this be encouraged, this arrangement that the AG entered into with Dr. Kwabena Dufo, should it be encouraged going forward?
No, it shouldn't be. But there are circumstances in which the complexity of the case would direct that on a rational basis, maybe you should cut your coat and run whenever you can.
Let's leave it here for now. And as always, a pleasure speaking to you, Dr. Tony Edu, former Ghana's ambassador to the Netherlands, and of course, leading member of the NS. Let's take a short break here on the pulse and return. I will take you to Boko. Of course, we are back here on the pulse. This is Pulse on Joy News. Now, let me take you to Boko, where the Nigeria police is outraged over what it describes as an arbitrary and unjustified curfew imposed on Nairobi and the surrounding communities. In a strongly worded statement, the police condemned the government failure to consult the office of the Nairobi before announcing the dusk to dawn restriction effective July 27, 2025, calling it blatant affront to the authority and dignity of the Mampu. The police insists there is no conflict in the area to merit such a drastic measure. We'll bring you details of that shortly. But first, students of the Nalerigu Senior High School were evacuated earlier today to safety. This follows the killing of 2 of its students on Saturday. And also, a student of Boko Senior High School was also pulled out of his dormitory, shot and killed at close range in the school premises by unknown assailants who scaled the wall and escaped. A daily curfew from 2 p.m. to 6 a.m. is currently in place. Here is Boko Municipal Director of Education, Isaac Abeko Azaso, noting the school closure is necessary to ensure the safety of both students and staff.
To give the school a temporary break so that we'll go back to our various homes, to our families, and at the right time, management will communicate back to you. We are most concerned about the final year students who have just about a week to start their exams. When the break is given, we first and foremost call the final year students back. Then it will be followed with the Form 2s and then the Form 1s who are here. And I think that is the best decision for now. If all of us should return back to our parents, we can put their hearts and minds at rest. But if we continue to keep all of you here, the number of calls your parents will be calling to find out what is happening. We want to assure your parents that all of you are safe. And we'll make sure that we create a safe passage for all of you to get back home safely. Those who cannot go when the break is given, special arrangements will be made for you to remain with security provided for you as well.
Right, let me bring in the Municipal Chief Executive for Boko, Isaac Azunaba. Mr. Azunaba, good afternoon. Welcome to the Pulse. And if you can kindly unmute for me. We still cannot hear Mr. Azunaba, the MCE for Boko, who joins us via Zoom. So if you can kindly unmute for me so we can hear you as we try to understand the situation as we speak now. Is 4:22 p.m. meaning already they are the residents of Bako are back in their homes observing the curfew, which is at 2 p.m. to 6 a.m. every day. And we'll get Mr. Zunaba, can you hear me now? Yes, great. So it must be a difficult time for you as MC. 6 months into the administration and it's baptism of fire already.
True, my brother. True. It's not easy. But by the grace of God, we're on it.
So as we speak, it's 2 p.m. Everybody is in their homes observing the curfew. It's past 4 it's past 4 p.m.
Yes, it past 4 p.m. Everybody is in their homes observing the curfew.
So what is the situation now? Is it calm, tense? What is your understanding of the situation in Bako today?
Generally, it's calm. We haven't had any issue from yesterday to today. Generally, the municipality is calm.
So as of now, every student is out of the Bako Senior High School campus?
Yes, please.
But you know that those who are writing the WASI, they have just 1 week to write. What is the arrangement for them?
Yeah, so we have arranged together with the school authorities to transport these students with an escorted security to the campuses on the 4th of next month, I guess. They will be starting the exam on the 5th. So we'll bring them on Sunday, which is 4th, and then the following Monday, they will start the exam. We are engaging all stakeholders, including the traditional authorities, the communities, the surrounding communities, to be part of this peace building process, this safety measures we are putting on the campus for the students to write. We want them to support the process so that these students will have a safe environment and a peace of mind to write their exam. From the date of starting to the last day, they will stay on campus. In addition, we are going to station security in the campuses, specifically the policemen will be stationed in all the campuses within the municipality to ensure safety for these students to write their exams.
And so, but what if the student is not resident of Bako? Probably, let's say in the northern region, in the Ashanti Bono region, and now that everybody has been asked to go home, what is the arrangement for such? Are they going to stay on campus?
Yes, they are going to stay on campus with the security in place. And as I said earlier, we are making plans to transport these students. We are going to have buses to most of the places where students are coming from. We will transport them back to the campus, and we will ensure that the security is in place to keep them safe to write their exams.
What about healthcare delivery? Is it in any way affected by the conflict? Other government institutions, like, for example, the Assembly?
Oh, yeah, sure. You know, the curfew is 2 o'clock. Most offices close around 3 p.m., especially as you talk. The health facilities, they run shifts. As they run shift, by 2 o'clock, the morning staff have closed, and then new set is coming. So how the morning staff will close at 2 o'clock and go is a challenge. How the new staff will also come is also a challenge.
But are they being provided with security? Because sometime back, the Ghana Medical Association, they declared that their members were under attack and was making it difficult for doctors and nurses to even accept postings to Bako.
Yeah, so I'm being in talks with the security agency to support sex staff with escorts to and fro from their homes to their workplaces.
All right, we'll leave it here for now. We are monitoring the situation. Please stay safe for us. That's the MCA for Bako. In a related development, the Ashanti Regional Coordinating Council has initiated stringent security measures following the killing of the Kusasi Chief Abdul Malik Azangbe. Let's hear what those measures are with my colleague Nanaya Ojima, who has joined me live from Kumasi. So Nanaya, tell us, I mean, the renewed measures that the RECSEC has already put in place.
Yes, Elton, there are a number of them that are already in place to ensure that the Ashanti region does not see a repeat of the shooting incidents that we saw last week. About 3 of them were recorded last week, leading to the death of 3 people, including the Kusasi Chief of the Ashanti region. Now, there is halt on the use of motorbikes in between the hours of 7 p.m. and 6 a.m. on daily basis. So there are police checkpoints to ensure that no one uses motorbikes within these periods. Also, there are restrictions to the number of persons that motorbikes can carry. Now, aside the rider himself, nobody is allowed on a motorbike. So it's just one passenger. Normally, you see the motorbike rider and one other person behind the motorbike rider. But now it's been limited to just one individual. Also, there are some clothing that are not to be allowed when people are on motorbikes. So when someone is riding a motorbike, for instance, if you are riding a motorbike with a smoke, it's not allowed. So the police checkpoints are also to check all these things. Also, people are not allowed to carry weapons from one point to the other, and including people on motorbikes, others in vehicles. No one is allowed to carry a weapon to commute. So these are among some of the security measures that are in place to ensure that the Ashanti region does not witness another shooting incident. Now, in Asawase, to be specific, there are a number of security checkpoints and within the Asawase enclave. Now, within the Zongo enclave, you see, this morning I went in there and I encountered about 3 different security checkpoints. Even on a stretch, you can witness about 2 of them, and some of them are manned by policemen, more than 7 policemen, well armed, and sometimes you see a few military personnel within among these policemen who are supposed to man these checkpoints. Now, in the Kumasi Metropolis, generally, the snap checks, the checkpoints in the Kumasi Metropolis have increased. Yesterday, I was within the Ahonjo enclave, and I was checked about 4 times by these security men who are on the ground. So security have been beefed up in the Ashanti region, Kumasi to be specific, and these numbers are doubled within the Asawase Metro.
Well, I guess we've lost Nanaya Ojima on the line, but he is reporting from Asawase, where they've stepped up security controls. Nanaya, are you still there? All right, so we'll leave it here for now, and then this is a developing matter. We'll keep an eye on it. Now, let's talk politics now. The political battle lines are being drawn in Akwatia as the ruling NDC take the lead in what is shaping up to be a fiercely contested by-election. Even before the Electoral Commission rolls out an official timetable, the NDC has fired the first salvo, officially opening nominations today, with the window set to close on Wednesday. Now, meanwhile, the opposition MPP is yet to formally announce its timetable for the parliamentary by-election, though speculations are rife, with former member of parliament, Amase, emerging as one of the likely contenders. Now, whilst the MPP prepares to open nominations for a flabbergasting race tomorrow, its silence on Akwatia is drawing some attention. Let me begin with the development within the NDC. And my colleague, Kenneth Jesse, joins me in the studio. So, Ken, let's start with the NDC.
Right. So the NDC, just this afternoon, we're getting indication that Bernard Bediakun Beidu has picked his nomination to contest the Akwatia by-election just hours after they officially...
Do you know who this person is?
All that we know is that he's a lawyer. Not
Okay.
much is known about Bernard Bediako Baidu, who has officially picked his nomination to contest in this particular by-election. But the NDC released a statement outlining some modalities, and the statement was signed by its General Secretary, Fifi Kwete, which urged all prospective aspirants and party stakeholders to adhere strictly to the guidelines. It says that per the directive, nomination forms will be available at the party's Eastern Regional Office and must be returned to the same office upon completion. Aspirants will only receive the delegates list after confirmation of payment of the approved filing fee into the party's official account at the Adabraka branch of the UMB Bank. No check or banker's draft will be accepted. Now, the party, in a bid for inclusivity and gender equality, says that women and persons with disability who will be contesting in this particular primaries will have their filing fees slashed by 50%.
Right. And we don't know what the MPP program is, even though we know that per the rules, if official communication is sent to the Electoral Commission by the Speaker of Parliament, the EC must organize by election within 30 days.
Yes.
Is it clear whether such official communication has gone to the EC?
Well, it is clear that such communication has gone to the EC, because I was speaking to my sources within the MPP. They said they recently held an IPAC meeting where deliberation on which date to set to conduct that particular by-election should be on. It was settled somewhere within September, but we don't know which particular day in September. So yes, the EC is aware of this particular incident, which led to the death of the Ernest Kumi, who was the MPP's MP in that particular constituency.
And then the MPP, they have their own timetable.
Yes, so the MPP, as of now, has not officially opened nomination for the Akwatia by-election, but they will open nomination for their presidential primaries tomorrow, and it will close on the 28th of August. Now, these are the modalities for that particular presidential primaries, which will be happening in January next year. It says the vetting of candidates will take place from September 15th to 22nd, with the vetting committee submitting its recommendations to the National Council on September 29th. And petitions related to the nomination and vetting process may be submitted between September 30th and October 3rd. An official list of nominees is expected to be published on October 8th. It says the balloting will occur on October 10th, followed by the issuance of a notice of poll on October 17th. And the presidential election, as I mentioned earlier, will take place on the 31st of January 2026. And in the case that nobody secures the 50% of the vote, the runoff is scheduled for the 14th of February.
Is there any indication of a super delegates conference?
Looking at what they agreed upon, the motions that they voted upon within their last conference that they held about 2 weeks ago, we don't have any indication of such an event that will happen. So these are the modalities for their upcoming presidential polls somewhere in January 2026.
Thank you very much, Ken. So the two parties up and running, the NDC, they've got a timetable for the upcoming parliamentary by-election at Akwatia. The NDC parliamentary by-election at Akwatia, they have a timetable. The MPP, they've got a timetable for the Congress to elect a flag bearer of the party in January. Folks, that's our show. For more stories, log on to our website, myjoyonline.com. And like I always say, whatever you are up to in the hours ahead, I hope it's profitable. My name is Elton Robbie. Have a good evening.